Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murdersheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
Temp check. What kind of summer are we having this year? A family road trip summer? A beach bum summer? Or a wake me up when the sun sets summer? With Instacart, choose your own adventure and skip the shopping side quests. Where available, you can get ice cream delivered to your hotel, sunscreen to the pool, or cold brew to your bed. Well, door, in as fast as 30 minutes. Wherever you find yourself this summer, you can get the goods. Download Instacart for free delivery on your first 3 orders. Offer valid for a limited time. Minimum $10 per order. Excludes restaurants. Additional terms and fees apply.
Getting the smile and confidence you've been dreaming about, all from the comfort of your home, isn't a total mystery with Byte clear aligners. Just don't be surprised if all your friends start asking, "What's your secret?" Begin by ordering your at-home impression kit today for only $14.95. Byte clear aligners are doctor-directed and delivered to your door. Treatment costs thousands less than braces, plus they offer flexible financing, accept eligible insurance, and you can pay with your HSA FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
Content warning: this episode contains discussion of the murder of 2 girls.
Well, there has been a flurry of new filings in the Richard Allen murder case, of course, the Delphi murders case. And so we are going to discuss them with you now, and maybe between all of us, we can try to figure out what some of it might mean and maybe get some idea about where things might be going from here.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the Delphi murders, continuances, dismissals, and recusal requests.
So before we get into the many, many things that were filed today,
on a Friday afternoon/evening,
I'd like to actually jump back and talk about a couple of things that were filed yesterday on Thursday, May 16th, 2024. Judge Gull actually issued on that date yesterday 3 separate refusals to various media outlets who had asked to record court proceedings. And she has pretty consistently been refusing these requests. And this has always bothered me. I think this is one of the more important criminal trials that's ever happened in the state of Indiana. I think there are a lot of people who have an extraordinary level of interest in the case and how it is being handled. And for me, it seems like it would be appropriate to make these proceedings as open as feasible. Obviously, everyone in the world who's interested can't go into the courtroom, but we could turn on our computers and watch a feed from it or listen to an audio feed. So I've always been troubled by this.
Yeah, I mean, I'll inject a little bit of analysis of my own here. I do feel like, I certainly am for cameras in the courtroom, but I believe we were going to get those before the leak. That's my belief. I don't necessarily have any evidence to back this up, but I think that it was full steam ahead with cameras, and then the leak happened, and then considerations changed, and now we're not going to get them. So that's just yet another fallout from how much of a circus some people have made this case into. And I would say that while I don't agree with the judge's conclusions, I certainly understand that perhaps there's a sense of, how do we not make this into a 3-ring circus? It's perhaps already a 1-ring circus, but how do we not make this Barnum and Bailey? Because a lot of people seem to want to, and I think there's a perception that the cameras will exacerbate that. And I think, in my opinion, the cameras might not exacerbate it because it might prompt some people who are going to be especially clownish to just stay at home. But nonetheless, I guess I strongly disagree, but perhaps understand it.
Yeah, I'd actually think cameras in the courtroom might make it less of a circus, because right now it's not even clear what kind of media passes or anything would be given.
Right.
A number of people have been saying, "Oh, I'm going to come in."
It's like, good luck with that, friends. I don't know if we're going to get in, man.
I'm going to come in. I want to watch some of the trial or what have you. And so there's a scarcity mindset around this. And when you have a scarcity mindset and a lot of people want it, there's going to be more of a circle.
Can you imagine being the families of the victims, where all these people are clamoring to get into what's going to be perhaps like the hardest several weeks of your life? And it's just like a thing to go to for some people. I mean, it's hard. I mean, I imagine it's difficult for them to understand the level of interest here. And I think most people's interest is very well intentioned. I don't think it's meant as rubbernecking, but I imagine it must be really surreal for them to see that. And then there's the matter of what you mentioned of media access. That would be, I think if you're going to not have cameras, it would be great to really bend over backwards for the media that is going to be there, because then I think you can have people who are going to accurately record, what's happening and, tell the public. I think you should have one or the other. And unfortunately, we have neither at this point, and I hope that changes, but who's to say? It probably won't.
With all that said, why don't we get to the first of the filings that happened today? You want to read from this? It's a motion for a continuance
from Richard Allen's defense team. Yes. So I'll be reading 3 paragraphs, starting with paragraph number 3. Quote, "The defense has recently conducted discovery in the form of deposition of Dr. Monica Walla, the psychologist assigned to Richard Allen at the Westville Correctional Facility. The deposition commenced on Wednesday, May 8th, 2024, and is yet to be concluded due to time restraints. The parties are in the process of scheduling the remainder of the deposition, which is likely to take place in early June of 2024. There were questions posed during the deposition that were not answered by deponent Dr. Walla at the direction of her legal counsel. The defense moved to certify these questions and therein preserved the right to seek the court's intervention in obtaining answers to the certified questions. Additional time is necessary to not only conclude the deposition, but to attain certified transcript that might otherwise be used as evidence in the hearings on both parties' motions. This could assist in shortening the presentation of evidence regarding said motions."
Okay, so there's a lot to unpack there. First of all, the thing that struck me immediately about this motion is this defense team clearly was not ready for a trial on May 13th. They're not even ready for a pretrial hearing that takes place next week.
This is a person who heard perhaps a very important confession in this case. And they hadn't talked to her yet?
They hadn't even talked to her until a few days before the trial was scheduled to begin.
How is
May
that possible?
8th.
How is that even possible? That's what I want to know. How is that possible? How can you claim to be ready for May and then, yeah.
So when we hear them say things like, oh, we were definitely ready to go, and it was just, oh, the mean judge didn't give us the time we wanted, otherwise we would have gone.
No.
I'm not sure I credit that because it seems like they really were not prepared.
I'm going to tell you this. I don't credit that at all.
I don't understand why they waited until May 8th, 2024 to depose this witness.
I don't understand that. I don't understand how a thing like this happens. What was this? If they went in May, if they had gone in May, would this have just been some sort of reverse Perry Mason moment where, I mean, I don't understand it. Thank goodness they didn't go in May from that perspective, because they were obviously not prepared to defend their client, which is sort of their whole job. So that's interesting. This is also really interesting from the perspective of what's going on with Dr. Walla, right? So we find out that she has legal representation there with her at this deposition. One thing that comes to mind is she, as a mental health professional, needs to consider things like confidentiality. So I don't know if that's something.
I would assume that Richard Allen, through his lawyers, could waive confidentiality if he's competent to do so.
If they just learned about her, then maybe that paperwork was incoming. Maybe they weren't ready with that either. So I don't know if we can really necessarily read too much into any of this, because this is not like a typical defense team and this is not a typical situation. So it's really hard to understand why does she have legal representation? What specifically is she declining to answer? Is it about
what is she declining to answer?
Is it about stuff with her? Is it about stuff with him? I'm very curious.
I wouldn't read anything into her having legal representation, because it is common sense. If you are going to be deposed in a murder trial, even if you have nothing to do with the murder, and even if you have not done anything to put yourself in any legal jeopardy whatsoever, it still makes sense to have a lawyer sitting by you to protect your interests, because it's like you're going into a dark and dangerous jungle without a map.
I mean, think about Professor Jeffrey Turco, who, of course, is not implicated in anything. He's just a witness who happens to know about Norse culture, runes, things like that. It almost sounds like, reading between the lines, he might regret not bringing in a lawyer to depositions, because what he said was then seemingly twisted around by the defense team later on. And when you're a professional who is an expert in something, I imagine that's painful to have your expertise in words twisted around publicly. So always have a lawyer. We salute the lawyers because they will protect your interests. But yeah, I mean, so it's interesting. She's declined to answer some things, but Judge Gull can force her to answer.
If her lawyer says, oh, she shouldn't answer that question because it's irrelevant or it's immaterial, the judge in theory can say, well, no, I think it is relevant. You should answer that.
All right.
It's also interesting to note that Nick McClelland objected to this continuance.
So it's interesting because oftentimes I've seen speculation that, the defense really wants to go ahead, but the judge and the prosecutor are dragging their feet. In the motions, I read the opposite. And that's, at this point, that could shift at some point, but that's what I'm reading. I feel like there's one party that does not want to move forward in terms of timing. And I think that while the defense rhetoric tends to center around speedy trial, we wanted a speedy trial, I don't believe that their actions have indicated that.
Have you ever covered a carpet stain with a rug, ignored a leaky faucet, pretended your half-painted living room is supposed to look like that? Well, you're not alone. We've all got unfinished home projects. But there's an easier way. Thumbtack is the app that makes it easier to care for your home. Pull out your phone and in just a few taps, search, chat, and book highly rated pros right in your neighborhood. Download Thumbtack and start caring for your home the easier way.
This episode is sponsored by AutoTrader. Credit scores, down payments, interest rates. Car buying can be a numbers game, but you don't have to be a math expert to get the keys to your dream car. Just use Kelley Blue Book My Wallet on AutoTrader. Crunch your numbers and get your personalized results so you know exactly how much you'll pay each month for your car. It's like having a magic wand for your wallet. Presto! The car you've been wanting is now within reach. So hit the road and leave your calculator at home. Find your next car on autotrader.com.
Everroot dog supplements can help keep your dog feeling their best every day. Ever playful. Ever curious. Ever thriving. Visit everroot.com to learn about supplements that can help with your dog's unique needs, from multi-benefit to skin and coat to hip and joint, because every dog deserves to feel their best. Everroot dog supplements, powered by Purina.
So let's move on to the next filing. This one is filed by the state of Indiana through prosecutor Nick McClelland, and it is a motion to dismiss the defense's motion to suppress certain statements.
That was filed on April 11th, 2024.
You may remember the defense filed a motion that said, Richard Allen confessed to a whole bunch of people, or at the very least made incriminating statements to a ton of people while he was incarcerated. And by the way, we don't think any of those should come into the trial. And they didn't really go into any details about why they thought specific statements should not come into the trial.
Right.
Do you, Anya, want to read a few relevant paragraphs from Nick McClelland's response?
Certainly. Quote, that the defense seems to imply that there are statements made by the defendant while he was incarcerated that were coerced by state actors during a custodial interrogation. That the defense fails to put the state on notice which state actors coerced the defendant, fails to outline which statements they are seeking to suppress, fails to state how the defendant was coerced in a custodial interrogation setting, and fails to outline the basis for their motion. That under Criminal Rules of Procedure 2.7b, when the defendant files a motion to suppress, the defendant must clearly state the items or statements to be suppressed and the basis for the suppression. That the state contacted the defense and requested that they fix the deficiency in their motion, but the defense refuses to give the state any guidance on their motion to suppress and refuses to comply with Criminal Rule 2.7b. That the defense has failed to outline which statements they wish to be suppressed, who the state actors are that coerce the statements, and the basis for the suppression, end quote.
So that's basically, what we were saying. They said, the defense said originally, we just want all of these statements suppressed, and didn't give any reasons why. Instead of saying, this particular statement was given in a way that is unfair to Richard Allen. Like he may have been manipulated into this particular statement, so this particular statement shouldn't be used. They didn't do that. They just said everything should be thrown out. It's an all or nothing thing. And I think, quite frankly, I wouldn't be surprised if we got detailed information about each one of these dozens of confessions or incriminating statements. I wouldn't be surprised if perhaps some of them were suppressed, but it's difficult to imagine that each and every one would be.
I'm going to say this. This is my opinion, some analysis, but I believe that they didn't want to go into detail about what exactly they wanted suppressed because it would be, in their mind, damaging to the public perception of their client. So good luck with that. But I mean, if it's going to be damaging, they treat many of their filings sort of like press releases. It's trying to, put together their narrative. And if you have things that, even if there's maybe some grounds for suppression, they still sound really bad and people start thinking, why would this guy be saying this? Then I think they feel like that is an existential crisis because they are so focused on the court of public opinion. Two, this is interesting, but in their first Frank's memorandum, this sort of famous document, we all know it from the case. Some consider it art. Some people maybe think less highly of it. And this is a situation where they included in what I consider a notorious footnote that I don't know, haunts me to this day, that they don't have any specific allegations about Odinist guards in Westville forcing Allen to confess by threatening his family. But
maybe it happened. Like, the vibes are there. We don't have any names or like specific information about what happened. And Alan certainly isn't saying that, but the vibes. And that's a problem because also, I mean, it's a prison. Things are being filmed. Like, if there's evidence there, then that's important to disclose and show. But I mean, what McClelland's getting at here is that they lack the specificity that you would need to possibly see some movement on this suppression.
Specificity and like
Friday night, folks,
and like reasons or evidence. Like imagine if Anya, in a fit of mad power, says,
no.
Kevin, you can never eat fast food again. And I say, Anya, that's too vague. That doesn't make any sense. That's not fair. You're excluding too much. And then Anya says, well, Kevin, if you get this particular dish from this particular restaurant, it has MSG in it. That causes you headaches. Kevin, if you get this other particular dish, it has too many onions in it. That's going to upset your stomach. And so if Anya then goes through and cites specifics, you shouldn't get this item, you shouldn't get that item, because it would cause you problems, then okay, then maybe I don't get those items. But she was too broad when she said, Kevin, just don't get any fast food ever.
Why are you unpacking our dirty laundry in front of the listeners? That's my first question. But my second statement is yes. So
a rare non-serial example.
Thank you for sharing the burden. No, you're very correct, and it's very it's apt, and frankly, I mean, it's indicative to me that the prosecution reached out to the defense about this and said, you need to be more specific, and the defense said no. Again, I see this as more of them considering this from a PR standpoint rather than a legal standpoint, which might seem backwards to a lot of people, but that seems to be what they're doing. I think they consider most things through the lens of public opinion, media opinion. How can we put out our narrative when that can sometimes run counter to the legal side of things?
Are we ready? Got a lot to cover here, so we're ready to hop on to the next one?
Let's go back. Yeah, let's do it.
Next one is the state's response to defense's fourth motion for a Franks hearing. And why don't you hit us with the opening of that?
Quote, now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and files its response to Richard Allen's fourth Franks motion based on newly disclosed evidence and request for hearing, referred to by the state as the defense's fourth motion for Franks hearing. That, as in the previous three Franks motions filed by the defense, this fourth motion illustrates a complete misunderstanding of the ruling in Franks v. Delaware and the purpose of a Franks challenge to a search warrant. The defense makes the same allegations in this motion as it has in its previous three motions, that Sheriff Tony Liggett failed to advise the judge of material facts, and that without these omissions, the search warrant would not have been issued. The defense consistently, in the three previous Franks motions, have misstated and mischaracterized facts surrounding this case. That trend continues in this most recent Franks motion. Quote,
I think the thing that really is crystal clear there, I think it's probably been clear to most of us for quite a while, is there is no love lost among the different figures in this case.
That's a pretty brutal opening, yeah. I agree. Just that you don't understand the law, and you repeatedly 4 times.
And then he, excuse me. And then he goes even further, because then he's talking about
basically
the
phone pings, which we've heard before.
You remember a while ago, the defense filed a motion about geofencing, and Nick McClelland responded by saying, you clearly don't understand what geofencing is.
And then proceeded to explain in detail all the things they had wrong about geofencing, which then the defense conceded essentially in a following filing where they said, well, we just didn't have enough time to learn about geofencing. Sue us.
So there's some deja vu here, only instead of geofencing, it is phone pings. Because you remember they filed this motion in which they tried to suggest, Libby's phone was pinging hours after it was supposed to be dead, therefore something nefarious is going on.
Yeah. Which, of course, everyone loves, because, online loves the idea that this case is far more complicated than the prosecution seems to believe it is. So got a lot of buzz, got a lot of excitement from a PR perspective. That's good.
But now what McClelland is saying is that I have the facts on my side, and that indicates that the technology and the findings here are not at all what you've described in your filings.
Because you're misunderstanding them.
Or misrepresenting them.
He says here that these phone pings were the phone pings from Libby's phone were historical in nature. The question is, what does that mean? And he does explain that. Do you want to read that section, please?
Yes. He talks about, quote, historical. Well, I'll before I get into the quote, he talks about how essentially the last known location where service is good counts as a historical ping.
So then he talks about what...
And he talks about what exactly that can mean and talks about how it's not a pinpointed location and accuracy can range from 400 meters to 25,000 meters. And that can basically be coming, several factors can influence how wide a range that is. But
the big issue here is, how was a phone that may not have been in working order generating these historical pings?
Yes. So, quote, and this gets into, by the way, a law enforcement officer, Sergeant Edwards, who's involved in the investigation. So, quote, Sergeant Edwards later says, with AT&T, part of the reason why it says historical here is that if they say, all right, we're going to ping that phone, but they can't get to the phone, well, then they'll use the last known location from the historical records. That is different than the live ping. It's going back to the historical records saying we can't find the phone right now, but here's where we know it was last. The ping emails collected all show historical data. That means that the tower could not find the phone at the moment the ping was initiated, so it just gave the service provider the historical data location. That doesn't mean the phone wasn't in the area or that the phone wasn't in working condition. It means that the tower could not contact the phone. The historical data continues through all the pings. So essentially what they're saying here, in my interpretation, Kevin, correct me if you have a disagreement on this, but Libby's phone dies or has, stops working, goes offline. The tower cannot find it when it's trying to ping her after the search is initiated or after a certain point. So it draws from the historical pings where the phone was last connected to something. Connected to the, I guess,
so
service.
These were not live pings. These were pings to a phone with a dead battery, which is in no way inconsistent with anything the prosecution has claimed. And so if we take this at face value, again, it means that the defense filed a motion about pings in which they didn't really understand what the technology meant.
And this is what's interesting to me, because I mentioned before there's this discrepancy between the defense's strategy around media and legality. And when you have a situation like this, you get the momentary serotonin boost of having a lot of people get excited on your behalf online, which can feel really nice, I imagine, having supporters. But at the same time, when there's not necessarily when that's not necessarily backed up by the facts, then it just causes a loss of credibility, in my opinion. And I think that's concerning.
In my opinion, it feels like a lot of the things the defense has been alleging in some of these motions, like this phone ping motion. If the phone ping motion had come out a year and a half ago, I think it would have generated a lot of interest and suspicion from huge members of the public.
I would be intrigued and like, wow, this could really be a huge deal.
But at this late date, after we who have been following the case have read a lot of filings from this defense team, I think a lot of the reaction I saw online was, well,
sure,
this probably isn't going to pan out the way they think it will.
Yeah.
They've really damaged their credibility with the public. And as I've said before, one would hope that they don't do some sort of version of damaging their credibility like this in front of a jury. Yeah,
right now we can all say, my opinion doesn't matter. Kevin's opinion doesn't matter. It's going to be the jury's opinion that matters. So it could go either way. If they play a clean game, so to speak, in trial and do a good job, maybe they can make something happen. I don't know. It depends on how bad those confessions are, I think. But they can at least not embarrass themselves. That being said, we see the same pattern again and again. Overstatement and checks that bounce. And they can't have that happen in trial. It's really important. I'm concerned about the quality of representation that Ellen is getting here. If they're making mistakes about basic technology that at this point they should understand. And if they're just mischaracterizing it to get one over on the judge, then that just sort of seems like a waste of everybody's time.
Do we move on?
We move on.
Next thing is an order from Judge Gull, who is responding to the request for a continuance. Basically, she said, well, if you guys aren't ready to proceed with Dr. Walla, we'll continue the hearings that pertain to that. But for the rest of the hearings, let's just go ahead and have them.
I see this as the judge being reasonable with the defense saying, if you need more time for that, take it. But let's do everything else. There's no reason to put that off, right? Right?
Well, the next filing is a motion to continue hearings on all matters currently set to be heard May 21st through May 23rd, 2024. As the title suggests, in this motion, the defense is asking for everything to be continued. And the reason they say they're doing this is because pretty much simultaneously with this filing, they were also filing a motion for Judge Gull to remove herself from the case. And the idea here is, let's say I'm about to sell my house. Should I have the power to make decisions about how the house is going to be painted for the new owners or different furniture for the house? Or does it make sense for at some point for me to say, well, these decisions can be made by the next owner? And here they're saying, if there's a chance there's going to be a new judge on the case, why not let that new judge make all those rulings? And they cite some case law for that.
Right. And in addition to that, they talk about how they recently received from the state some sort of phone extraction, and that they believe that the witness who extracted the phone data will be important for their third-party theory of Odinism. So one thing about a case like this is if there's continuous threads sort of unfurling, discovery will come up. That's not surprising. It's also not a discovery violation necessarily, as long as it's new. And the state cannot sit on it, but the fact that they continue to give the defense this stuff indicates that there's still more coming down the pipeline. So it's very vague about what this is. We don't know what it is. And they want more time to dig into that so they can present it for why they believe that the Odinism theory is valid for, presentation in court. Personally, I think that this filing to me shows an indication that we're going to get a lot of delays in this case. When I saw this, I don't know about October anymore. I thought that perhaps if we didn't get May, we'd do October. Now, if we get a lot more like this, I'm going to say, nah, this is just going to drag on endlessly.
Point 15. The trial has been continued until October 14th, 2024, which should provide an abundance of time to find new dates to conduct said hearings.
One would hope. So are we going to bounce along to...
Let's bounce along to the big one.
Yes. So it's a big one. It's got a big title. Defense second verified motion to disqualify judge and request for findings of fact and conclusions of law upon denial of this request, if this court denies this request. Okay.
What does that mean? What are they asking there?
Judge Gull, leave. And if you don't leave, tell us why exactly you don't think you should have to leave based on the facts and the law. If you don't do what we say. Is that a good legalese translation?
Yeah, that's good.
Okay. So they talk a lot in this. This is 40 pages, and we're going to be trying to go point by point. So keep in mind, we're going to be on this document for a while. This is going to be most of the rest of the episode.
Yes.
So strap in. They start out talking about how the rules of court say essentially that if a reasonable person could infer bias in a judge, then the judge must recuse themselves.
A lot of things in the legal world come down to what kind of a burden you have. Reasonable doubt, for instance, is a burden. You can't find a person guilty of a crime unless it's been proven to you beyond a reasonable doubt. That's a pretty high burden. The burden they're suggesting being used here is a much lower burden, much easier to meet.
Reasonable person, someone who's not biased themselves, somebody who's just kind of coming into it, maybe doesn't know everything about the law, but they're willing to hear everybody out.
Yes.
So, I mean, it's going to be interesting, and we can talk a little bit about that at the end, but I want to just say and state that that's sort of what they're bringing up in the beginning, that in their opinion, a reasonable person would find that Judge Gull is biased against them and their client. That's also an important distinction here.
Let me read point 8. After the Supreme Court quickly reinstated the defense following oral arguments on the same day, the Indiana Supreme Court did not grant Allen's request for Judge Gull to be recused, based upon the limited record set out at the time by Allen's appellate counsel.
Why are they firing shots at the appellate people who literally got them back on the case?
I guess the implication there is they didn't do a good enough job explaining why Judge Gull has been unfair.
That surprised me when I read that because, again, the appellate team got them back on the case.
And the appellate team... obviously, if you're in a situation where you've had a long-term relationship with someone and you want to discuss them, how they've been bad to you, you're not going to sit down and list all the hundreds of things they did that upset you. You're going to go through the record and find what you think are the strongest arguments, the strongest things they did that were most upsetting to you.
Actually, that's a strategy of boiling down your best points and leaving out all the extraneous nonsense that I think this defense team could really benefit from.
So I would argue that the appellate counsel did not include every single thing they could, but I would argue that they went through the record and pulled out the most compelling, strongest arguments. And if those arguments weren't enough to win, I'm not sure if the result would have been different if you'd included another dozen or two lesser arguments.
Quantity does not beat out quality when it comes to legal arguments, I think, in this situation. And actually, prioritizing quantity consistently actually just looks like nitpicking at the end of the day. There was one quote we wanted to pull out here that gets into sort of the federal side of this and then the legal side of this. Point number 6 before we move on. So, quote, the accused has federal due process rights to an unbiased judge under the 5th and 14th Amendment to the U.S. Constitution. Judicial bias is one of the narrow classes of constitutional violations that implicate structural error. Cases of judicial bias involve denial of the most fundamental constituents of due process, so fundamental that conviction in their absence is indecent, even if the defendant is plainly guilty. Structural errors render criminal trial fundamentally unfair and are not subject to harmless error analysis.
So they're saying if the judge is biased, that's so serious, automatic new trial. And the sentence that really jumped out at me from what Anya just read.
Even if the defendant is plainly guilty.
Even if the defendant is plainly guilty. And I've said this before, part of me wonders, are they abandoning their claims that Richard Allen is factually innocent?
I think that they will go down with that ship no matter what, because I believe that this is a legal team that is focused on a specific narrative and they're focused on a specific image, not only of their client, but more fundamentally of themselves. And I do not believe that they will abandon that. I believe they'll go down with it. And that's possibly to the detriment of their client.
Well, at this point, why don't we read the list saying all the things they say Judge Gull has done wrong, and then we'll go through it point by point and discuss it in more detail.
Yeah, this is the case against Gull according to this defense team.
Ani's going to read it for us.
Yeah. In addition to the reasons cited in his January 28, 2024 motion, Judge Gull has revealed rational inference of bias towards the defense based on the following. A. Judge Gull engaged in ex parte communications with the state of Indiana. B. Judge Gull interfered with properly subpoenaed defense witnesses. C. Judge Gull treats the prosecution more favorably than the defense. D. Judge Gull engaged in the act of prosecuting Richard Allen by inviting the prosecutor to file pretrial motions seeking limitation of evidence of third-party culpability and also forecasting the outcome of such a request by the state. E.
Judge Gull continues to make disparaging comments about the defense counsel in open court and in orders issued by the court. F. Judge Gull's handling of defense pleadings versus her handling of prosecution pleadings. G. Judge Gull placed blame on defense counsel and its staff for administrative failures in maintaining confidentiality of ex parte defense filings, whereas evidence revealed that failures were on the court's side of the filings. H. Judge Gull failed to conduct her own internal investigation into allegations of leaks coming from her own staff, while facilitating contempt proceedings against Richard Allen's chosen attorneys for leaking confidential information related to this case. I. Judge Gull effectively denied Richard Allen his right to a speedy trial by not requiring the prosecution to follow the same time restrictions at trial as she was forcing the defense to follow, which forced the defense to seek continuance of the May 13th, 2024 speedy trial date. End quote.
Okay, so that list sounds pretty bad.
Yeah.
If you just take that list at face value, that list sounds pretty bad.
Yeah.
Is that fair to say?
I completely agree.
But let's go into it.
Fortunately, they provide more details about what exactly they're talking about, so we can analyze
So
those.
we can evaluate these things point by point, and it's important to realize where there's smoke, there is not always fire.
Well, as we found out with a lot of different filings in this case, claiming things does not make them true. Important thing to remember here.
Okay, so the first thing on that list is ex parte communications and interfering with defense witnesses. This involves largely Robert Bastone.
There's just can't get rid of this guy in this case. Just definitely.
Can you give us like a 30-second primer just on who this guy is?
Robert Bastone is a convicted child molester turned prison house attorney who has filed frivolous claim after frivolous claim against various parties, Westville, Indiana Department of Correction, various people there, about how awful they're making his life. He also is known for slut shaming effectively the child, the small child that he molested. His DNA was found all over her swimsuit. She identified him as her attacker. And I believe, and I think most people would agree with me, that he has extreme credibility issues. The reason the defense is all over this guy is because at one point he seemingly was willing to come in and talk about how Richard Allen was being treated worse than anyone else in Westville. So he was useful to the defense at that point, but his calculus changed and sort of that didn't happen.
Defense wanted him to appear. They filed for him to appear. When the sheriffs came to get him from his cell to bring him down to appear at a pretrial hearing, he refused.
Yes.
Strenuously refused to participate.
Said he was scared, all this, excuses. We've had communications with him, and we found that he was ultimately more interested in pulling a bait and switch where he would claim knowledge about things regarding Allen, but then ultimately wanted us to more focus on the injustice he was facing. So this is something that he does. This is a pattern of behavior.
And so he refuses to leave the cell, strenuously refuses to leave the cell. Sheriff Tobe Blesenby, who is trying to get him from the cell, contacts Judge Gull, says, this potential defense witness, he's refusing to leave the cell. What do I do? And Judge Gull says, well, if he refuses, there's not much you can do. Let's just forget about it. And so there's a couple of issues there they're claiming. First of all, they're saying that if the defense wanted Bastone to come and testify, even if he refused, then law enforcement should have been required to, quote, use whatever means necessary to transport the inmate, end quote.
That's an ominous phrase, so I guess that includes violence, like tase the guy and drag him bodily out of his cell and force him into a transport and then force him up on the stand. Is that what they're asking for? Because that's sort of what it sounds like.
And that's a little bit surprising given how concerned they are for Richard Allen's rights in prison. It doesn't seem like that necessarily extends to anybody else. I mean, I think this is a bit shocking given that, I as you can probably hear from my voice, I find this Bastogne character rather not credible and rather, what he's accused of doing is just horrific and does not seem, I'm not saying he's not credible because he's an inmate. I'm saying he's not credible because he doesn't seem to have actually taken any accountability for what he did to a child who he attacked and traumatized. But that being said, I don't believe that people should be dragged around and forced to testify if they change their mind. I think that in his position, and ultimately all of this is over nothing because this guy is not believable. He's not, he was going to make some talking points for them, but this is not, he was going to say whatever, he says whatever he thinks people want to hear so he can get involved in a high profile case and get more attention on his own case. That's what happened here. And to be acting as if this is some kind of like, they should have, beaten him into submission in order to make this happen. That's just preposterous.
So they're upset that she didn't require them to use whatever means necessary to get the guy out of his cell. They're also upset that she communicated with Tobe Lesenby about this. And then in another point here, they say that Tony Liggett, who's now the sheriff, has been communicating with the judge about the logistics of where to house Richard Allen during the trial. They say, hey, she was talking to Tobe Lesenby. She's been talking to Tony Liggett. They're both witnesses in the case. That's ex parte. That's bad. But from what they're saying, she's not talking with them about the substance of their testimony. She's talking with them about the logistics of what these people are doing to do their jobs, the jobs they were elected to do. And I'm not aware of any case where if like a police chief or a sheriff is going to be a witness in the case, the judge can't ask them questions about logistical matters, about how the jail is being run or things like that.
Yeah, that's not how it works. It's just not. In addition to all this, the defense also suggests that, rather interestingly, they suggest that Nick McClelland.
Let's talk about this.
Yeah, the prosecutor.
So you remember there was an email that Brad Rosie included in a filing where Judge Gull said something about, I'm well aware of the rules about suggesting that third parties might be the actual guilty people in a case. In other words, she's aware of the law in when it's okay for defense attorneys to come in and say, well, my client isn't guilty, Anya Kane is guilty, or what have you. And so they are saying that when the judge said this, I think the implication is Nick McClelland was very naive, and the idea of filing a motion suggesting to limit their ability to introduce the evidence about Odinism had never even occurred to him until Judge Gull had this offhanded remark in an email. And that's what gave him the idea. Therefore, she's giving him strategy. I think that's a bit disingenuous. I think certainly we've talked to many defense attorneys and prosecutors of other cases behind the scenes. Everybody has been expecting that he'd be filing that at some point.
This has been, are we going to have the Salem witch trials Odinism redux, or are we going to have, the defense will be forced to do something else like pick apart the prosecution's case? That has been the central question for a long time. You've probably, if you follow this case online, you've probably seen discussion of this before. It's not like it's been some secret strategy that only Judge Gull could have cooked up. I think that also seems disingenuous. I don't think it's a strong point.
Next point, Judge Gull has repeatedly disparaged Richard Allen's appointed public defenders. What's your take on that?
This is basically a section that says Judge Gull is very mean to the defense attorneys, and that is not fair because they are very good. That's pretty much the vibe here. Interestingly enough, we've certainly seen her call them sloppy and incompetent. I think within what she's talking about, I think people can maybe understand that. I think it's interesting that they don't mention that
I mean, one thing that's kind of like lacking the smoking gun here is that I think a judge who is purely out to get two defense attorneys, she had them in her sights with contempt. I mean, she had a clear shot at them with that. Had she wanted to just, punish them, embarrass them, fine them, throw them in jail rather, not prison, but that would have been an opportunity to do that, and she didn't take that. So that complicates their narrative that they're putting here. I think a lot of people would rather be criticized than put in jail or fined thousands of dollars. And so the fact that she ruled with them on that, to me, for a reasonable person, I think it complicates that. It harms their ability to make this work to the same extent. So I don't know. It's kind of like when you're talking about having a person be able to walk into an attorney's office and get access to a ton of sensitive discovery and then disseminate it all over the internet, it sort of feels like maybe you don't agree that it's the attorney's fault, but I think we can also understand where a judge is coming from when she feels like your handling of that was incompetent and sloppy. So I don't know. I don't know how compelling I find these points about her being mean.
The next point is rather vague. Other examples of Judge Gold treating the prosecution more favorably than the defense. And the example they bring up is the example of a YouTuber named Gary Baudet, who online uses the name Fig. He, according to their allegations, had some interactions with prosecutor Nick McClelland. Also, Gary Baudet had some information about the bullet found at the crime scene. And so the inference they're drawing is that Baudet got that information from prosecutor McClelland. Therefore, prosecutor McClelland is also a leaker and should face whatever they're facing, I suppose.
So the defense team in this situation, led by its own counsel, David Hennessy, had an entire contempt hearing to convince the world that McClelland was leaking to Gary Baudet. He did not do that. There is a difference between taking information from individuals like Gary Baudet, which McClelland and other investigators are certainly allowed to do, and they're also allowed to respond to them in the context of that, versus leaking information. It's a one-way street versus a two-way street. A one-way street's fine. A two-way street is problematic. And I don't feel like they were able to give any concrete evidence of that. And in addition to that, I think it's interesting that they continue to harp upon their own leak to a certain extent. Like I guess it's not enough to be found innocent of contempt or to not be found in contempt here. They have to keep bringing it up. I don't believe a lot of this reads as face saving to me about their own leak. And I think that's, if I were them, I just wouldn't bring it up again. I wouldn't, they don't have to bring it up. I wouldn't.
Let's be blunt. If they really think that Gary Baudet was receiving leaked information from Nick McClelland, produce some evidence. Maybe that evidence is testimony under oath from Mr. Baudet. I don't know. But by all means, go ahead and pursue that if you think that's what happened and you think that's relevant. But with that said, I really think it is worth stressing that there's really no moral equivalence between a piece of information leaking and graphic crime scene photos leaking.
I completely agree. I mean, I'm not convinced that I'm not convinced that what they're saying about the alleged Baudet leak is even pertinent to anything or relevant or even what they're claiming it is. I'm just not convinced at this point. But if it was, or there's some truth to that, I also completely agree. The fact that images of murdered children got out and were published ultimately on YouTube is a disgrace, and everyone involved in that. I mean, it was a disaster. It affected people. It affected this case. It's been problematic for everyone involved. And to me,
there's no moral equivalent of that with anything they're even claiming at this point. And it just, certain things are going to be worse. A department store is going to make a bigger deal about the theft of like a very expensive handmade sable coat versus some cheap costume jewelry earrings. They're both bad. They're both theft. One is going to set off more alarms, understandably so, because it's more problematic. And the sensitive nature of what Mitch Westerman put out there through his friend, Andrew Baldwin, the claim is that it was without Baldwin's knowledge, that had a real world impact on people. And it caused so much harm and so much hurt, just untold amounts. So I'm just going to say that, I guess that's why I'm surprised they continue to bring it up. It sort of feels like they're trying to say, oh, it's all the same. And I get why they're doing that PR wise, but like legally, I just don't understand. I mean, I don't know. It just seems like a mess.
Yeah, they also say that there didn't seem to be much interest shown in another investigation because Mr. Bodette also supposedly claimed that he had a source who was working for the judge. Why didn't the judge believe Mr. Bodette and conduct a full-scale investigation? I don't know.
Why don't they?
Yeah, they can conduct an investigation.
They could easily,
if they want.
If they wanted to subpoena and depose Bodette, I mean, if they truly feel like this is a good use of their time, they're able to do that. The fact that they haven't sort of indicates that perhaps this is more of a faint side issue.
They write, quote, "The fact that Judge Gull has treated the defense differently when the defense is accused of a leak than it has treated her own staff or the prosecution creates rational inference of bias against the defense," end quote. I would respectfully suggest if she's treating them differently, it is because, again, the leak of graphic crime scene photos of deceased children is a lot different than the leak of a piece of information. No one is suggesting, to the best of my knowledge, that Mr. Bodette received like actual secret court documents or anything of that nature.
I'm gonna say this. With the Westerman leak, you have graphic crime scene images of children and other discovery pieces get out there, and then very quickly Mitch Westerman comes in with this bizarre story about sneaking into his good dear friend and former employer's office and doing this. It sets off a lot of alarms, frankly. On the Bodette side, you have possible contact between McClelland and Bodette, and maybe Bodette knew something he shouldn't have, but we can't prove where exactly that came in, and he's not exactly explaining where that came in. And we don't know how to verify what he even claims. So those two things are not the same thing. And so I don't believe a judge, regardless of who's doing it, I don't know. You would need a lot more with the Bodette situation for me to say that is a red alert situation.
The next point, Judge Gull wrongly blamed the defense for ex parte filings which were inadvertently directed to the prosecutor. This, you will recall, refers to an incident where Nick McClelland received and subsequently referred to ex parte filings made by the defense, which were not intended for the public and certainly not for McClelland to see. And they're saying, well, after this came out, Judge Gull in an email apparently suggested that it was the fault that someone on the defense team must have done something improper.
Yeah.
And this is a little bit familiar to me because I don't know how many of you remember it, but in the middle of that whole business of the leak, there was a point where Judge Gull sent an email saying that Anya and I should be thrown in jail.
And anytime the audio's weird on this show, you should just assume that we're in jail.
So she said that, but she never threw us in jail. And I would note that if she, in this email that they referred to, said that this filing confusion was the fault of the defense, but then she never took any action based upon that, I'm not sure what the long-term harm is.
In addition to that, this is a defense team that has lied directly to her about their intent to try this in the court of public opinion.
This is a defense team that has accidentally sent emails to convicted felons who then put it on their YouTube channels. This is a defense team that allowed their competent strategist slash mortal enemy slash dear friend, Mitch Westerman, saunter into their, main office and leak stuff all over the internet. Actually, I can completely understand why you would be perhaps first to scrutinize their actions when something goes wrong in terms of something being released publicly that wasn't supposed to, because they do have a history of that. I'm not saying that's fair. I think it's better to just hold your tongue until you have evidence against somebody. But in the situation of like the logistical, how this all has been handled, I can understand that.
The next point, accusations of violating rules on access to court records. They say, well, earlier Judge Gull didn't do a good job of maintaining court records, and so some appellate attorneys filed with the Supreme Court, and so basically put her in a position where she had to correct the court records, and she calls us sloppy. So isn't that basically it? Judge Gull made a mistake, and how dare she?
Whomst amongst us? Yes, Yeah.
So it's true the court records weren't being kept as well as they should have,
and then it was corrected.
So I'm not really sure
Where's
I
the issue
understand
there?
how this shows a bias.
It doesn't. It's just a lot of these things are. This is actually why I think the appellate attorneys were, maybe more choosy about what they put out there, because some of these things you can sort of understand, or you can see a kernel of something, or maybe you find compelling. Either way, I think others are very weak, and you shouldn't include stuff that is very weak, because it just undermines your overall. You're just kitchen sinking.
Defense motions are treated differently than those of the prosecution. Their big complaint here is that, and I call it their big complaint because they make it over and over and over and over again in this section. They say that when Nick McClelland filed a motion for contempt, a hearing got scheduled pretty quickly. When we file motions, they usually are either turned down or there's no hearing at all, so unfair.
Judges have discretion. It's important for a judge to be allowed to use that discretion to make rulings, and ruling for or against somebody, a party, is not typically considered to show bias. There can be many reasons to rule against somebody. Perhaps they're doing a bad job in filing sloppy and poorly done filings. Perhaps you don't agree with their interpretation of the law. Perhaps this or that. I mean, this is not a lot of this at this point. I felt like they started with some ones where I could understand where they're coming from. At this point, I feel like this is, to be blunt, I believe scraping the bottom of the barrel.
Judge Gull ignored the defense's request to set aside 2 weeks to present Mr. Allen's defense while refusing to set any time limits on the prosecution. This is about the hearing on May 7th. Where they were upset because they did not feel like they're going to get enough time to present their case at trial.
Yes.
And they said because she didn't give us what we wanted, therefore we had to delay the trial, and that violated Allen's right to a speedy trial. Before you say whatever you have to say, and I'm sure you have some things to say, I just like to repeat what we said earlier, that they plainly were not ready for this trial, and I strongly suspect that even if she had granted them whatever time they wanted, they would have found another reason to seek delay. And I'd also like to repeat that Judge Gull indicated that based upon her reading of the rules, she didn't have the power to extend the length of the trial to that late date based upon the fact that she'd already promised the jury it would be like a 2-week trial.
I go back and forth a lot in this situation between, by this situation, I mean this whole case, between dishonesty and incompetence, which is worse, right? Dishonesty would be not intending to ever go in May and just having it be some sort of pretext in order to stave off getting thrown off the case again, or perhaps posturing so that your online fans think that you're really tough and you're making it all happen, and I don't know. That's dishonesty. Incompetence is thinking that we can maybe do May when you really should be realizing that there's no way May is going to happen. You can't effectively defend somebody when you're not ready. And there's no way you're going to be ready by then. And you're just wasting a bunch of time on other things. And you're like deposing important witnesses 2 minutes before this thing is supposed to start. So those are the two options. And I guess I don't know which is worse at this point. I mean, I guess dishonesty is better because it shows at least some strategic input. I'll say this about this time limit thing and the, I think it's interesting that the defense frames it as the entire onus of the delay is on Gull. I do agree to a certain extent that, in my opinion, from what I'm reading in the filings, Gull did not check in about this at any point. I think that would have been good. That how long do we need again? Are we sure 2 weeks is enough? Those are questions that I think a lot of people would have asked.
I think a lot of people would have asked that prior to sending out the jury.
I think that would have been good to ask. That being said, I don't believe the entire onus of the delay belongs on her shoulders. I think that if they wanted it to go in May, it had been scheduled for 2 weeks for a long time, and they had plenty of time to sneak in there and say, actually, we need 4 weeks, or we need 3 weeks, or here's exactly how long we need. They didn't do that, seemingly. A lot of their behavior does not match the rhetoric that they put out there. They can be saying May, oh my gosh, speedy trial, and if they're not actually working to get there, then I have a hard time believing that that is either sincere or you could just assume that there's some catastrophic breakdown within their team where they're not functioning as they're supposed to be functioning. So, I mean, personally, I think given what we've seen from this defense team, there is a legitimate concern about them grandstanding and wasting a lot of time during this trial. I believe that they deserve the time they need and not a minute more, because that's not justice. That's not effective defense of their counsel. That is posing for the cameras. I mean, it's not the same thing. So, I mean, I wish that there had been more conversations between the parties going into this about what exactly they need, but I don't feel like May was ever going to happen, and I certainly do not feel that Judge Gull somehow manipulated them into October. And at this point, if things continue to go at this rate, October seems like a long way away, but I don't know if they're going to be ready for October at this rate.
Ready for the next one?
Yes.
Okay. Judge Gull engaged in extrajudicial activities that raise a rational inference of bias, especially when Judge Gull may have to rule on how the extrajudicial activities of a key state's witness will impact the admissibility of Richard Allen's purported confessions. So that's a big mouthful. I'm going to start by Judge Gull's extrajudicial activity. On July 29th, 2023, she left a post on a Facebook page about a softball tournament at the Abby and Libby Memorial Park.
Which one of her relatives, I believe, participated in.
Yeah, somebody posted what an honor it was for the girls to play in the Abby and Libby Memorial Tournament. What a greater honor it was that Abby and Libby's grandparent present our girls with their championship finalist rings. And Judge Gull commented, congratulations.
Okay.
So they're saying that this sporting event at a park, the fact that she commented on something, a one-word comment pertaining to who won the sporting event, she's commenting on something that I guess that's somehow an issue in the case.
Right.
That's a little hard to understand.
I think that's a stretch. I can understand where they're coming from here, but I do think it is a stretch.
If there was some sort of rally being held saying, let's lynch Richard Allen, and the judge posted underneath it, that sounds great.
Yeah, that'd be more of a problem.
That would be a problem.
Yeah. I mean, I guess it has to do with the park itself. That seems, it's a park. I mean, it's memorializing these girls. That's true whether or not you think Richard Allen did that. Hopefully you don't have a problem with it, although frankly a lot of people who are, I would say, defense conspiracy theorists seem to have an extreme problem with the victims' families and anything actually memorializing these kids. So unpack that as you will. Let's get on to the fact that some of the victims' grandparents were involved in this.
I feel like they've been pretty quiet since the arrest. I don't feel like they've been out there advocating for one thing or another. I mean, am I like, when you're looking at their social media, it's like, remember the girls, you know, we hope to get justice at some point. They're not out there being like, this guy did it and here's why. I mean, so I guess
And this sporting event in particular was just a sporting event at the park named after the ones they've lost, and congratulating people for winning an event.
You could also argue that the congratulations is about winning. It's not I mean, like, it's so vague. It's not like, congratulations, I find these people very inspiring and I hope to do a good job ruling in their case, wink, wink. Like, it's too vague. It's, again, there's something here. I understand why they're doing it. I don't think this is one of the dumber ones. I just think it's not a lot of meat there.
So here's why they're bringing it up now. We spoke earlier about Dr. Monica Walla, who it appears heard or somehow received a statement or confessions from Richard Allen. It has come out that Dr. Walla was a member of several Facebook groups devoted to discussing the Delphi case.
We've not confirmed this independently, we should say. I'm going to say allegedly because it seems like, and we've reviewed screenshots of somebody with that name seemingly being involved. Do we know that that's do we know for a fact that that must be her? No, but it certainly has gotten a lot of buzz. I think that's fair to say.
It's gotten a lot of buzz. We haven't mentioned it because we couldn't confirm it, but now the defense is mentioning it.
So we ought to talk about it, yes.
We need to talk about it because the defense is saying she's a member of all of these groups. She seems like she was even a member of the Murdersheet group.
Yeah.
And I've seen what purports to be a screenshot from Dr. Walla in which she talks about some of her favorite YouTube channels devoted to discussion of the case.
I think she mentioned on actually mostly pro-defense sided people, interestingly enough. So make of that what you will. She was not just in our group. She was in a lot of different Delphi groups, if that is the same person.
And if it's the same person, it raises some interesting questions that, a person so interested in the case, a case buff, happens to be the one who receives a purported confession.
I guess it depends on what you consider a case buff. And to me, I think to me what the difference is. Some people get their news from Facebook, from social media. That's the landscape we live in. If a newspaper, a local newspaper, was doing a really good job of covering a local crime and you were consistently reading that, I don't think many people, it would be hard to make a big issue of that. I think, you wouldn't be in any sort of like online thing where everyone can see you. To me, belonging to groups and sort of being passive in that respect doesn't seem like a huge deal. If you are actively sleuthing and talking and theorizing with people, that's where I think things can start to become uncomfortable.
I think it's a worthy subject of inquiry for the defense.
I concur.
And I can tell you, I've been members of Facebook groups. You've been members of Facebook groups. Oftentimes when you're a member of a Facebook group, you meet people, and even if you don't comment publicly, you might have private conversations with people in the group.
Or you would just get interested in a subject briefly, join a bunch of groups, and then mute them, or you don't really go on Facebook much and you don't really pay much attention to it. I guess what I'm trying to say is
I understand what you're saying.
Yeah, no, I'm just saying the scope of behavior here could be very concerning for the prosecution to not really concerning at all. And we don't have all the information.
Yeah, if you would go on my Facebook profile and look at all of the groups I've joined, it's like some sort of bizarre museum of things I've had.
You're like excavating your past interests.
Things I was interested in for a few minutes one day.
And again, some things would be really problematic, in my opinion. Some things would be maybe iffy, borderline, and then others would be innocuous, frankly.
Yeah, so this could be a big deal. It could be no deal at all. It could be anywhere in between. But again, I definitely feel like this is a worthy subject of inquiry.
It could be bad for her and not necessarily bad for the case against Allen. Like, there's so many possibilities.
There's so many different possibilities. So they're raising it here in this context because they're saying, can Judge Gull be expected to make fair rulings about people commenting extrajudiciously on Facebook when she's done the same thing herself.
Yeah, I think it's a valid line of inquiry for the defense around Walla. I think the link to Judge Gull's highly innocuous post seems a stretch. So in the context of this filing, I don't really find this super compelling. In the context of they could maybe make a lot of hay about the Walla situation, they could do something with that if the facts align with what they want.
Yeah, and you could also make the argument if Judge Gull saying congratulations is relatively innocuous, that doesn't mean that she therefore is obligated to rule that anything anybody says on Facebook is also innocuous.
Yeah. I mean, if Dr. Walla in some hidden group or in some secret Discord was saying like, this guy's totally guilty, there's a difference. And I think what the problem here is they're using this to try to get Judge Gull to recuse herself. That is the point of all of this. That's all of this information that they're giving you. It all goes towards that. But from that perspective, I don't think this is compelling from the perspective that they could have some, they could try to discredit Walla as a witness if there's information there. That would be possible if the facts, again, align with what they want.
Judge Gull has impaired Richard Allen's ability to defend himself by denying his reasonable request for expert and administrative staff funding.
And then they admit that they've been filing bills wrong. Oops. So, quote, for example, the defense has paid $26,000 for the work its investigator performed in the spring, summer, and fall of 2023. When Judge Gull was not satisfied with the format of the investigator's bill, the defense tendered new bills to meet the court's expectations. Because the investigator deserved to be paid for their work he performed, the defense paid the investigator out of its own law firm account. End quote. So, yeah. So they've been filing bills wrong, and that seems to indicate what's been going on there. That just seems like prudent, maintenance and making sure that people are spending money as they should be instead of just getting blank checks to do whatever they want. So I'm surprised that they even put that in there.
Let me read this next one. Evidence.
Oh, gosh, this one.
Evidence that public confidence in Judge Gull has eroded due to continued improper conduct and conduct that creates the appearance of impropriety. And what they're citing here is we've all of us who've been following this case and following the docket know that for the last couple of months, periodically, people will send Judge Gull emails basically telling her she's no damn good. And then she dutifully enters them all in the docket because that's the appropriate thing to do. And they're saying, well, the fact that she's getting mean emails means that people don't like her. And there's many, many responses to that. Do you want to start or do you want me to start?
You start.
I can tell you that if you were to look at our inbox, yes, there would be people in our inbox who hate Judge Gull. There's also people in our inbox that really think the world of Judge Gull. So even if you jump to the conclusion that the way to make legal decisions and determinations is based on emails, the people who write Judge Gull, that's not a scientifically valid sampling.
Sometimes I wonder if the defense wants to have the trial replaced with one of those American Idol style things where you can text in what you want the verdict to be. Because sometimes it just seems like they're really more trying to play to what they perceive the crowd to be rather than, the laws or anything else. And I think what's interesting about that is that, and this is something that they may not realize, it's very easy to fall into an online bubble. It's very easy. Algorithms are created by very smart people in order to get us in online bubbles and to kind of show us things that we agree with and to make us increasingly extreme in our views. And what's interesting is that what we found is that there's a lot of all over the place thinking about this case. Some people are very virulently pro-defense. Some people are mildly pro-defense. They're open to disagreement. Some people are mildly pro-prosecution, open to disagreement. Some people are quite convinced that Allen is guilty. Many people who are actually on both sides of that equation believe that the defense are doing a terrible job and messing things up left and right. Others think that they're, the second coming of Clarence Darrow. So people are all over the place. I will say that it's been our observation that I believe that there is evidence that indicates that social media personalities that are aligned to the defense side of thinking encourage people to reach out and sometimes send very hostile and sometimes, frankly, rather uncivil emails to Judge Gull. So the fact that that's happening, I think, kind of puts the thumb on the scale to a certain extent. And I also would argue that these are not everyday citizens who are sending these emails. These are people who are obsessed with the Delphi case. And that they, to the point where they think that they can take a stand and their voice needs to be heard. And I don't think everyday people are doing that. I think everyday people like go to work and maybe follow the case on social media or the news.
Or excellent podcasts.
Like the one you're listening to now. They're not doing that because they realize they have enough self-awareness to realize that, you know, we can send as many emails as we want. That's not going to affect anything, nor should it, frankly. You know, we should not have judges who are looking and saying, oh my gosh, you know, like Smoking Joe from True Crime 99 on YouTube is mad at me. Like, I better do things a lot differently. That's not how it's supposed to work, folks. Like, we don't want to live in that society. We want to live in a society where trained legal professionals are making decisions. And yeah, so I don't think these are everyday citizens. I think this is semi-coordinated. And I also, I think it's also like you have people who seek attention in the case. And we've seen some emails that strike me as that. I mean, again, many of them may be very well intentioned, but I don't think they don't read as if they come from people who understand how the legal process in this country works.
We're getting close to the end, folks. I promise. Judge Gull has refused to order the state to comply with discovery rules to the detriment of Richard Allen.
Yeah, I mean, we've heard a lot about how they admit that they don't really know where anything is and that they think the state should do their job for them. So I'm kind of not really super enthusiastic about this line.
Judge Gull has only allowed cameras in the courtroom once at the hearing when she knew one way or another that she was kicking attorneys Rosie and Baldwin off of the case.
So this is something that I know behind the scenes we've talked about a lot, and I know this has stuck with you in particular.
This has always bothered me. It feels like that. It's always bothered me. That's not felt to me entirely proper. It felt like that was plausibly a way to try to put pressure on Baldwin and Rosie. The fact that this was the only time she allowed cameras, and since then she hasn't allowed cameras for reasons she's never really fully explained. So this has always bothered me. I don't think it's bothered you as much as it bothers me.
It would be nice, in my opinion, to get an explanation of why then and not now. Get it on the record. I completely see your point. I don't know if it's hit me as hard as it has you, but I think there's a point to be made there, and I think having clarity on that is important. Because again, why now? Why not now? If it was okay then, why was it okay at that point? Why wasn't it okay before then? Having some clarity on the issue would be helpful.
Yeah, that would be
for me to assess it. There could be some. I guess I come from the perspective of, you know, certain things I don't necessarily know. And there might be other considerations that I'm not even thinking of. But, you know, I think the optics on that are bad.
Yes. Okay, I think that's pretty much it for this filing, right?
We made it. Thanks for sticking with us.
Final filing, Richard Allen's affidavit in support of his second verified motion to disqualify Judge Gull and request for findings of fact and conclusions of law upon denial of this request if the court denies this request. So this is basically a signed statement from Richard Allen saying, yeah, I agree with all of this. At first glance, Allen's signature looked a little bit blurry and dotted to me. But then again, Rosie's signature also looked blurry and dotted a little bit. So I don't know if that last page was like faxed or something.
Well, yeah, let's talk about that last page. So they also don't have a date next to Allen's name.
Yeah. Which
I think is significant. I don't generally want to read too much into this. Like too many people have treated this case like it's like the freaking Da Vinci Code or something. And I'm not trying to do that. I do find it a little interesting that the font is obviously larger and clearer on the first page than the second page, which is smaller, more cramped, less clear font. And then page 1, the bottom number 41 is typed in a font, like typed on a computer. Page 2 seems to be hand lettered 42. So it's just odd. I wouldn't
care about that, except we're dealing with the signature page of a man who, in my mind, really needs to understand what's going on here. And I hope to goodness understands what's going on here, but I am not convinced understands what's going on here.
I would love for there to be some sort of independent third-party verification that Richard Allen fully understands this situation.
I strongly believe that Judge Gulls should immediately appoint an independent counsel that can speak with Richard Allen and determine that these attorneys, that Bradley Rosie and Andrew Baldwin, are in fact complying with his wishes, and that he in fact does approve of their strategy and wishes to go to trial. And the reason I say that is because he seems to have, at least at one point, been confessing to just about everyone who would listen that he was in fact guilty of these murders. And that makes me wonder, is this what he wants? Because this horrible, sad situation becomes an even more tragic farce if this is a man who is being dragged through this in order to satiate the egos of others. Anyways, thank you all for sticking with us. We appreciate you listening, and we hope you enjoyed the episode, and we'll probably be back sooner or later with some more Delphi stuff.
Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.
Your brand deserves better than one-size-fits-all branded clothing. Lands' End Outfitters creates apparel your team will want to wear, backed by above-and-beyond expertise. Go to business.landsend.com/pod20 and use code POD20 for 20% off your first product.